So what's happening so far in the first quarter? We've had 46 states in session, right? Not every state's always in session every year, so 4 are not right now. And even with the 46 states in session, even with it just being the first quarter, we're already tracking almost 500 bills that either regulate PBMs or touch on the prescription drug benefit. So far, what have we seen? We've seen 29 bills enacted. We've seen 38 pass that first step, passing one chamber, either the House or the Senate at the state level. We've seen 22 advance, right, 2/3 of the way, passing the first and second chambers. We've seen a few vetoes, right? Governors, when the bill hits their desk, have the right to sign it or veto it. And then we've seen multiple bills fail, so almost 80. And that's a quick breakdown of the first quarter. But I think what we're seeing is similar to last year, right? A high volume of bills touching on PBMs and the prescription drug benefit more generally. We're seeing, a good amount of those bills pass, make it all the way. That's that 29 enacted number. But what we're also seeing is more often than not, the bills are failing, right? So that's that almost 80 number we've got at the bottom. And that's what happened last year. And so far, we're seeing a lot of the same. And really what that means is that the PBMs, through their government affairs organizations, are having a lot of impact at the state level, kind of mitigating or defeating these bills. And what we've also heard are that plan sponsors are getting more active, running the numbers on what these bills might mean for their plans, and then contacting their legislators and saying, hey, either this bill would be great for our plan and our patients, please push this forward, or in other cases, this bill is going to cost our plan however much, right? And this is not good for a large employer in your state. So hear me out, Representative. And so we've seen both of those strategies work. And we'll give you an update on where we're at on the numbers next quarter. But so what are our hot topics at the state level, right? And all these bills, there's nearly 500 bills we've seen introduced. Well, it's a lot of the same we talked about at the federal level, but I'll call out a few differences. In your top left, we see minimum dispensing fees. That's something we're seeing more and more of at the state level. And what that says is that for each claim in the state, the PBM will pay the pharmacist a minimum dispensing fee. And usually that's tied to the state Medicaid rate. That's usually $10 or more per claim. So we've seen that pass in West Virginia. We've seen a version of that pass in Tennessee. In both cases, it's $10 to $11 per claim added to the cost of the prescription drug. So as you might think, a lot of employers, a lot of payers have raised their hand and said, wait a minute, this is going to raise costs on our plan. So that's an issue to watch. Another issue to watch in the bottom right-hand corner is ERISA erosion. And we'll get to this more extensively at the end of the presentation. But when it comes to ERISA erosion, we see states taking different stances. Some want to regulate ERISA plans no matter what federal law says, and they will write into the law that this applies to plans that fall under ERISA. Other states take a different approach, right? Maybe they heard from the ERISA lobby in their state, and they'll actually write into the law an exemption for ERISA plans. We've seen that as well. So continue to watch that issue, and we're going to get to that again at the end of the presentation. We've talked about delinking as an emerging issue. We've talked about the treatment of rebates. That's an issue at the federal level as well. Network restrictions is a classic issue, right? On the right-hand side of the slide, that can include any willing provider, right, that lets any pharmacist into the network. It might include the steering restrictions we talked about earlier. It might include a different kind of what I call flavor of the steering law, which are patient choice laws, which says that PBMs and plans cannot interfere with a patient's choice of their pharmacy. So look for all of that at the state level. That's popular and that's lobbied for by the independent pharmacists who feel they're being shut out of the PBM networks. Another emerging issue I'll call your attention to is gold carding. We're seeing this come up more and more. We talked at the federal level about regulation of step therapy, for example. Well, gold carding is targeting prior authorization as one of those utilization management tools that PBMs and plan sponsors rely on. And so a gold carding law would say something like a provider that's had a 90% approval rate in the past 6 months gets a gold card, right? And members who use that provider get to skip over the prior authorization process completely until we see that data change and maybe the gold card gets taken away. And so gold carding has already passed in a few states. Arkansas is one of those. Arkansas's gold carding rule is going into effect in 2025. So be aware of gold carding as an emerging issue. So let's dive into a few specific state laws that have passed. And these are a few of our high priority bills that have already been enacted. The first one I'll call your attention to is in Idaho. We've had a kitchen sink bill pass, and a kitchen sink bill is simply a bill that covers, a broad array of topics regarding PBM. So this bill, it deals with network adequacy. We talked about pass-through rebates. That's in this bill. There's a prohibition on spread pricing. There's steering provisions. There's a dispensing fee mandate, as well as some of those PBM transparency disclosure requirements. One thing I'll call to your attention, right, we expect this bill to apply to fully insured and also self-funded non-ERISA plans. But there's an important exception built into this bill for specialty drugs, right? We've seen that happen in a few states because there's usually an outcry from plan sponsors saying, if you want to regulate the prescription drug benefit, just stay away from specialty drugs. It's a small percent of utilization, but it's a big percent of our plan cost. And if we do anything to increase that cost more, right, it's going to harm the plan. So Idaho heard the policy argument there and has given exemption for specialty drugs when it comes to this regulation. Kentucky is the next state on our list that's passed a high priority bill. And this bill, again, is a kitchen sink bill. It's going to cover steering. It's got NADAC pricing built in. It's got the ending willing pharmacy provisions, and minimum dispensing fees are addressed as well. What's interesting about this bill is it specifically calls out self-funded plans, and it names governmental and church plans. So we know that they want to regulate self-funded plans in the state of Kentucky with this bill. I think the application of ERISA remains uncertain. NADAC and dispensing fee mandates under the 2020 Rutledge decision from the Supreme Court can be enforced on ERISA plans, self-funded ERISA plans. But we're going to have to study this bill more. We're going to look at the definitions. Do the definitions include ASO or self-funded ERISA plans? That remains open to interpretation. And one thing I'll call out, we're seeing this in a few bills, there's an exemption for health systems and hospitals that have in-house or owned pharmacies that would allow steering to their own pharmacies, and that wouldn't be caught up in the anti-steering provisions of this bill. So like our Idaho bill, this takes effect 1/1/2025. Our next state we'll call out is Oregon. We had two high priority bills passed there. The bill on your left was a kitchen sink bill, but the PBM lobby and through their government affairs teams, negotiated this bill heavily and really got it down to being, not that burdensome at all, at least on plan sponsors. The bill on our right, though, is one of these accumulator adjustment program bills. So look for that bill to probably ban accumulator programs in that state when it comes to fully insured or self-funded non-ERISA clients. Again, that would take effect 1/1/25. The next state on our list that had a high priority bill was Washington. This bill was originally proposed to be a kitchen sink bill, and it would have banned spread pricing and brought in other transparency requirements. But again, it was heavily negotiated, kind of like what we saw in Oregon. But the bill still addresses a few things. It's got steering built in, and anti-mandatory mail or AMO was also in the bill. But like we talked about earlier, there was an ERISA exemption negotiated into this bill. So it is clear that while it might apply to fully insured and self-funded non-ERISA plans, the ERISA plans are off the table when it comes to this Washington bill. And again, like our other bills, the parts that would affect plan sponsors go into effect 1/1/25. So we've talked about our priority bills that have passed. What bills are still on our watch list? We've got a few in Vermont, Rhode Island, and Pennsylvania. Again, you'll see there's just all the policy provisions we've talked about are showing up: NADAC, spread pricing, dispensing fees, etc. Then in Virginia, Kentucky, and Alabama, we've been watching a few priority bills there as well. Similar group of issues have popped up. I will say that in Alabama, that bill was defeated. It would have brought NADAC and the dispensing fees on the table, but that bill is no longer being considered. As we move on, we've got bills in Iowa, Wisconsin, a kitchen sink bill out of Illinois, and a couple of bills out of Missouri. that we continue to watch. I will say that I checked today, and as of now, the Wisconsin bills, those have failed to pass. So we'll take those off our list for the next quarter. Finally, don't forget about Alaska. Alaska is also looking to regulate pharmacy benefit managers with its own kitchen sink bill, along with California. The bill in Utah has failed to pass, so that will be coming off our list as well. One thing I'll call to your attention in California is that the regulators in that state have generally said that their state laws do not regulate self-funded plans. So one thing we want to watch is if PBM reform passes in California, will the enforcement agencies regulate self-funded plans through that PBM reform? We're not sure, but it's something that we'll have to study and continue watching. So I hope that helps as we run through state law. What are our top issues? Which priority bills passed? And then on this slide specifically, what priority bills remain on our watch list? So I hope that was helpful. Finally, we'll round out our presentation today with the status of ERISA preemption. This has been a big issue for our self-funded clients, right? The majority of those plans out there are those private self-funded employers, which are ERISA plans. And as a general rule, they're protected by a concept known as preemption that was built into ERISA. And preemption merely means that federal ERISA law will preempt or apply over any state laws that attempt to regulate the plan. So who are our non-ERISA plans? Those are governmental plans and church plans. Those types of plans are non-ERISA, and they are still governed by state law in most cases. So remember that ERISA plans, private sector plans, governed by federal law, not state. And then on the other hand, you've got non-ERISA plans, governmental and church plans, which can be regulated by the state. Now remember that ERISA was enacted with the policy of making multi-state employers have an easier burden of administration, right, when it comes to a multi-state plan. Instead of having to comply with 50 state laws when it comes to administering your employee benefit, you can comply with one law, right, and that would be ERISA. So as the states have continued to pass laws that regulate the prescription drug benefit, we've seen that kind of clash, right, with the ERISA plans in their state. Those state regulators are asserting the right to enforce these PBM laws, even in the context of ERISA plans. And when that happens, PCMA, that's the trade group for the largest PBMs, will usually bring litigation and try to fight back, right, against the state regulators. So our theme over the last few years has been PCMA has been on a losing streak, right? So if we start with Rutledge in 2020, that involved an Arkansas law that brought in NADAC reimbursement requirements in the state of Arkansas. That case went all the way to the Supreme Court, and they ruled that ERISA does not preempt those types of laws governing reimbursement between a PBM and a pharmacy. So that was Rutledge, again, all the way to the Supremes, unanimous against the PBMs. In 2021, and one level lower in the Eighth Circuit Court of Appeals, we saw the Webby case out of North Dakota. And that case ruled that general regulation of PBM practices, again, between the PBMs and how they contract or relate to pharmacies, that's not preempted by ERISA either. And then finally, in 2022, one level lower in a federal district court case in Oklahoma, we had the Mulready decision that went a step farther, right? It's not just reimbursement and Rutledge, it's not just PBM business practices and Webby. It's actually the PBM programs such as networks, steering, incentives, et cetera. Those aren't preempted by ERISA either. And so we saw 3 cases in 3 years, which really was working to erode at the protections offered by ERISA preemption. Well, where are we today? So last year, the PCMA appealed that decision, that Mulready decision out of Oklahoma, and they won on appeal in the 10th Circuit. And so the appeal makes clear that when it comes to network access standards, steering, or incentive programs, any willing provider, pieces of legislation, right, that let any pharmacist into the network, and even some of those PBM practices as they relate to the pharmacists, such as terminating their contract if they're under probation with their licensing body. All of those, are preempted by ERISA, meaning that they can't be enforced on ERISA plans. So when that happened, right, that introduces a split. You've got Rutledge, you've got Webby on the one hand, and you've got Mulready in the 10th Circuit on the other. And we're trying to understand what are the limits of preemption now. Well, we might find out, right, because the insurance commissioner in Oklahoma has announced his intent to appeal the decision, as well as, right, the Attorney General in the state of Oklahoma. Both have said they intend to appeal. So, for example, Commissioner Mulready, right, says that the decision from the 10th Circuit bolsters the power of PBMs, right, and is disappointing and will be appealed. And he announced that enforcement of the act will continue to the maximum ability of state law. So we're in an interesting scenario, right, where we've got this Mulready decision released. The insurance commissioner Mulready has said we will appeal. We're also going to continue enforcing as much as we can. So we think the Supreme Court's likely to take the case and decide the limits of ERISA preemption. Of course, we would welcome that because it would give more clarity, right? Whether they rule with the PCMA and the 10th Circuit, or whether they rule with insurance commissioners on the Rutledge and Webby side. Multiple states are still attempting to regulate ERISA plans, and in fact, they're bringing what we call extraterritorial regulations that would regulate plan sponsors even in states outside of the regulating state.